going to take a plea. You have been advised of your rights, and your attorney is going to be Mr. Haddad. Ms. Falk, Ms. Harris, please, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes, no?
Yes, ma'am.
Perfect, thank you. Ms. Falk?
Yes, Your Honor. On the position on the calendar, criminal trespass, 12 months, served 30 days, credit for time served 15 days from August 21st, 2025 until today, balance suspended, stay away from all MARTA per an act of suspension that ends on November 3rd of 2026. On the add-on 18 CR 011032C, time served 30 days, credit for time served 15 days from August 21st of 2025 until today. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea, and that's all for the state. We did, Your Honor, have an opportunity to look at her history, and she's not a frequent flyer in our jail, and so that's why we're asking for balance suspended instead of balance probated on this.
All right, thank you. Miss, who's hosting? Miss Grace, can you switch off the video for Sequoia Taylor? We'll address Miss Taylor when the defendants, but right now switch the video off. Thank you. And go put on a jacket. Go to your closet. Okay, thank you. Mr. Haddad, do you so stipulate?
We stipulate, Judge.
Thank you. Miss Harris, have you consumed any medicine or alcohol recently? I'm sorry, your audio is going in and out. Can you come a little closer, perhaps? Okay.
Yep.
Oh, no, that's not good. Francois, her audio is going in and out.
Let me try to.
All right, let's try that again, Miss Harris. Did you consume any medicine recently?
Yes, ma'am. My difficult.
Yeah, that's good. You don't have to tell me what it is. You just need to say yes or no. Okay?
Yes, ma'am.
And even after consuming that, are you still able to understand what's going on?
Yes, ma'am. I have to.
Are you satisfied with your attorney?
Yes, ma'am.
And if you decide to accept this plea offer, has it been explained to you that you would have to give up your right to a trial? You will not go back to court to face your accuser, challenge evidence that could have been brought against you, be able to present your own defenses and arguments, and the prosecutor won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up your rights?
Yes, ma'am.
How do you plead to 2 counts of criminal trespass, 1 from each case?
Guilty, Your Honor.
For the 18 CR case, your sentence is going to be to serve 30 days, credit for time served 15 days. You've already completed that, so that case is closed. For the later case, 25 CR 4977C, on the criminal trespass, your sentence is 12 months to serve 30 days, credit for time served 15 days, balance suspended. So this case will be closed now, but once you're released, you cannot return to any MARTA property, including the stations, the buses, the trains. You can't be at these parking lots or sidewalks until November 3rd of next year, 2026. You have more than a year suspension from MARTA. So not this Christmas, but next Christmas, you'll be able to go back to MARTA. Do you understand?
Yes, ma'am.
All right. Well, not Christmas, Thanksgiving, not this, but next in 2026. All right. Okay, that concludes your sentence. Thank you.
Thank you.
Next, our positions 1 through 3, Mr. Burks.
That's going to be a plea, Judge.
Thank you. That, okay. Cavasius or Cavacius, I'm not sure, Birts, B-I-R-T-S, has got 3 cases on our calendar, beginning with 25 CR 2889C, accused of battery from May 13th of this year, 25 CR 4946C, accused of possession of use of drug-related object and theft by shoplifting from August 18th of this year. And the third case is a bench warrant from August 1st, 2025, 25 FTA 1599. Mr. Birch, you've been advised of your rights, and your attorney is going to be Mr. Haddad. We are proceeding with the plea, Mr. Haddad.
We are, Judge. We're ready. It's a negotiable plea.
Mr. Birch, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
You need to
Speak up, please.
Yes, ma'am.
Thank you. All right, Ms. Falk.
Yes, Your Honor. On the battery position 1, 12 months served 34 days, credit for time served 17 days from May 22nd, 2025, and then from August 20th, 2025 until today. Balance probated, 12 weeks of anger management, and no further contact with Marcellus Copeland. On position number 2, the possession and use of drug-related objects, 12 months to serve 32 days, credit for time served 16 days from August 20th, 2025 until today. Balance probated in an ADET. Count 2, the theft by shoplifting, 12 months concurrent with count 1. Stay away from Walmart located at 4735 State Route 138 Union City, and 40 hours of community service or an anti-theft course, whichever the defense chooses. Finally, on the failure to appear, we will be entering a null pros upon the acceptance of the plea on this case. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. We would also like to sound for the victim in position 1, which is Mr. Marcellus Copeland at this time.
I don't see a Mr. Copeland. Mr. Copeland, if you're present, please unmute and start your video. No? Mr. Haddad, do you so stipulate?
Judge, we stipulate and we're requesting 40 hours community service on position number 2 in lieu
Okay.
of anti-theft course.
Got it. Thank you. Mr. Burtz, have you consumed any medicine or alcohol recently?
No, ma'am.
You need to say yes or no.
No.
And have you understood what's going on in your cases?
Yes.
Are you satisfied with your attorney?
Yes.
And if you decide to plead guilty to these charges, you would have to give up your right to a trial. You will not go back to a courtroom to face your accusers in front of a judge or a jury to be able to challenge the evidence brought against you, present your own defenses and arguments through counsel, and the state won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to battery from May 13th, 2025?
Yes. Guilty.
Your sentence is 12 months to serve 34 days, credit for time served 17 days, balance probated. You report to probation on Monday before 3 p.m. if you have no other holds. While on probation, you will start your 12 weeks of anger management classes within 60 days of being released, and you are to stay 200 yards away from Marcellus Copeland and have no contact with him. On the second case, how do you plead to possession and use of drug-related object and theft by shoplifting?
Guilty.
Repeat.
Guilty.
On the possession and use of drug-related object, your sentence is 12 months probation concurrent with the first case to serve 32 days, credit time served 16 days. Again, on probation, within 10 days of being released, you will undergo an alcohol and drug evaluation and submit yourself to any treatment that's required. For the theft by shoplifting, it'll be 12 months concurrent with count 1. You have to stay 200 yards away from the Walmart at 4735 State Route 138 in Union City. You'll also have to do 40 hours of voluntary community service at any nonprofit agency, but it cannot be a church and it cannot be a school. Your community service must be completed at a minimum rate of 5 hours per month. Thank you. And your bench warrant will be dismissed.
Thank you, Judge.
Francois, who do you have?
Next, Judge, we have position number 23, Mr. Mac Daniel.
Mr. Haddad, how are we proceeding? Please unmute.
It's gonna be a plea, negotiate plea, Judge.
All right. Daniel Mack is it Mac Daniel or Daniel Mack? I think it's Daniel Mack, yeah?
Daniel Mack.
Okay. Mr. Mack, your case is 25 CR 3282C, in which you were accused of theft by receiving of stolen property, and the other offense is acquiring a license plate for purposes of concealment from March 11th of last year. Mr. Mack, you've been advised of your rights, and your attorney is Mr. Haddad. May I place you under oath for the plea?
ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, I do.
Thank you. Ms. Falk, excuse me.
Yes, Your Honor. This on position number 23, count 1, 12 months served, 174 days, credit for time served 87 days from June 10th, 2025 until today. Balance probated, an anti-theft course, 40 hours of community service, no further contact with Catherine Scott, and stay away from 2480 Old National Highway. On count 2, 12 months concurrent with count 1, we would like to sound for Ms. Catherine Scott at this time, and we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
All right. I don't see a Catherine Scott on Zoom. Mr. Haddad, do you so stipulate?
We stipulate, Judge?
Okay. Mr. Mack, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am, I do.
Are you satisfied with your attorney?
I am. Yes, ma'am.
If you decide to enter this plea, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not go back to court to face your accusers, challenge the evidence brought against you, present your own legal defenses and arguments through counsel, and the state won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am, I am.
How do you plead to theft by receiving stolen property and acquiring a license plate for purposes of concealment?
Guilty.
For the theft by, I'm sorry?
Guilty.
Okay. For the theft by receiving, your sentence is 12 months to serve 174 days, credit for time served 87 days, balance probated. You'll report to probation on Monday before 3 p.m. if you have no other holds. While on probation, you will complete an anti-theft class, which you must enroll within 60 days of being released. You will do 40 hours of community service at a minimum rate of 5 hours per month with any nonprofit agency, but it cannot be a church and it cannot be a school. Stay 200 yards away from Miss Catherine Scott and do not contact her in any way, form, or manner. And stay 200 yards away from 2480 Old National Highway Parkway. And what city is that in? Atlanta?
Yes, ma'am.
I believe so, Your Honor.
All right.
College Park.
On count 2, it's College Park. That's right. And count 2 is going to be 12 months concurrent with count 1. Thank you.
Thank you.
Next are positions 14 and 15, Mr. Hardy.
Tyrese, middle initial S, Hardy, is accused of criminal trespass from November 24, 2024 in case 25 CR 808Y. He's got a later case 25 CR 4605Y in which he's accused of willful obstruction and criminal trespass from August 8th, 2025. Mr. Hardy, you've been advised of your rights and your attorney is Mr. Tom White. And I understand this is going to be a plea. Mr. Hardy, if you please allow me to place you under oath. Let's unmute courtroom 2. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
No.
Thank you. Ms. Falk?
Yes, Your Honor. On Mr. Hardy's case, the first criminal trespass, 12 months, balance suspended, stay away from the Exxon gas station located at 3985 Jonesboro Road in Union City. On position number 15, the willful obstruction, time served 46 days, credit for time served and I did the calculation wrong, 56 days, credit for time served 28 days. On count 2, the criminal trespass, 12 months served 56 days, credit for time served 28 days, balance suspended, stay away from Magic Market located at 3985 Jonesboro Road in Union City. That's to run concurrent with count 1. So just so your honor is aware, this is all like part of a shopping center.
Okay,
So we're asking him to essentially stay away from that shopping center.
all right. It's like a strip mall?
I believe so. I went and looked at it on Google Maps. Let me just go back and look at it really quickly. But yes, I do believe it is.
Okay. And Mr. White, does your client stipulate to a factual basis, venue and ID?
He does, Your Honor. We have
Mhm.
nothing.
Mr. Hardy, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in both your cases?
No.
You don't understand what's going on?
I just, well, I understand what I'm, incarcerated for.
All right, do you understand what are the charges? What are the basis of those charges? Do you understand that you are today entering a guilty plea and waiving your constitutional rights to challenge these charges as you are entitled to do so in a court of law?
Criminal trespass and obstruction, criminal trespass. That's what it says. You understand that?
Yes, I understand.
Do you also understand that you need to stay away from the entire shopping area at 3985 Jonesboro Road, which includes the Exxon gas station and another place called Magic Market? You can't return to that entire shopping mall area,
I understand now.
all right? And do you understand that these are going to be misdemeanor charges that will be convictions on your criminal history record, and that your criminal history record will be increased because of these 2 convictions, which won't make your record look very good?
Yes, I understand.
All right, so I'm going to ask you again. Do you understand what's going on in both these cases today?
Yes, I understand today. I
All
understand.
right. And are you satisfied with your attorney?
Yes,
And has your attorney explained to you that if you decide to plead guilty to these charges, these misdemeanor criminal charges, you will have to give up your right to a trial? You will not go back to a courtroom to have a trial in front of a judge or a jury. You will not be able to confront those accusing you of these charges. You will not be able to present your own challenges, defenses, and arguments against these charges. And the prosecutor won't have to carry her burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up all these constitutional rights?
no, I don't understand pleading guilty. I don't remember.
So.
All right. So,
Judge,
yeah, Mr. White.
this case was previously on our 11 o'clock calendar.
Okay.
It moved back, but what I understand, he is eligible to take a plea.
Well, I do understand that, but I'm getting all the wrong responses. So
I
I don't think he's entering a plea freely, willingly, and knowingly.
Judge, I understand. I think the point was that as long as we take the time to explain it in plain language,
Oh.
he'll okay.
And Judge,
Perfectly fine.
I'm here to assist as well. If the court wishes to ask the question again, I think I went over it again with Mr. Hardy, Judge.
All right. Mr. Hardy, I've just explained to you the rates that you will have to give up if you want to plead guilty to these charges. So I'm
Yes.
going to ask you again.
Yes,
Are you prepared to give up your constitutional rights and enter a guilty plea to these 2 cases?
yes, ma'am.
How do you plead to criminal trespass from November of 2024? Do you plead guilty or not guilty?
Yes, I plead that I'm guilty, that I did do, the charge.
How do you plead to willful obstruction of a law enforcement officer and criminal trespass?
Say that one more time.
This is your second case. You have 2 cases. Do you plead guilty or not guilty?
I plead guilty.
I'll accept your guilty plea for the criminal trespass in 2024. Your sentence is 12 months, balance suspended. You have to stay away. You cannot return to the Exxon gas station at 3985 Jonesboro Road in Union City.
All right.
For the August 2025 case, you, for count one, your sentence is to serve 56 days, credit for time served 28 days, and that's time served. For count two, that's 12 months to serve 56 days, credit for time served 28 days, balance suspended. You are to stay away from Magic Market, also located at the same location. In other words, you cannot return to the entire shopping mall at 3985 Jonesboro Road in Union City. Do you understand?
Yes, I understand.
If you return to that location, you will be welcomed back at the jail. Thank you.
All right, thank you.
Next, Judge, I have position number 29, Robertson.
And Francois, we are ready. I did have a chance to talk to ASG Skates. I did have a chance to then refer back to Mr. Murphy, and we are ready on Miss Pearson when court and
Okay, right after Ms.
Okay, thank you.
Robertson, we'll take up Mr. Murphy's client. Sharonda Robertson is accused of hit and run, failure to return to the scene of the accident, driving without a valid license, and following too closely from May 13th, 2025. Case 25 CR 4163J. Ms. Robertson, you've been advised of your rights, and your attorney is Mr. Haddad. And may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Speak up.
Yes, ma'am.
Excellent, thank you.
And Judge, I'm sorry, Ms. Falk, on the count three, it was converted to 30 hours community service instead of the $200 fine based on emails last week between me, you, and Mr. Shiroko.
okay.
It will be a total of an
Right.
$800
He-
fine.
Correct. We just, yeah, I think it was, I completely agree. Now that you've reminded me, I just think we forgot to update it in the system.
All right. Mr. Haddad, with this change on count 3 to 20 hours of community service, please stipulate to factual basis, venue, and ID.
We stipulate, Judge, and I believe, in all honesty, the recommendation was 30 hours community service,
Oh, okay.
not 20. I'll take the 20, but the state's offer was 30 for whatever.
Well, to be honest, given the fact that it was a $200 fine, it should have been 20. So I'm fine with 20.
Thank
But
you.
just so we understand, that'll make it 60 total hours because of the 40 on the driving hit and run.
That is correct.
All right. Final offer, 20 hours. Okay, I can't keep scribbling out. Okay, all right. All right, and Ms. Robertson, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your case? Repeat.
Yes, ma'am.
And are you satisfied with your attorney?
Yes.
If you decide to plead guilty to these charges, you would have to give up your right to a trial. You will not be able to go back to court to face your accuser, challenge the evidence brought against you, be able to present your own legal arguments and defenses, and the state won't have to prove the charges beyond a reasonable doubt. Have those waiver of rights been explained to you?
Yes.
And do you so waive these rights?
Yes.
Do you also understand that pleading guilty to these charges will add points to your driving history and your license will be suspended?
Yes.
Are you entering this plea freely, willingly, and knowingly?
Yes, I am.
How do you plead to hit and run, failure to return to the scene of the accident, driving without a valid license, and following too closely?
I plead guilty.
And Your
Well-
Honor, I just need to put the whole recommendation on the record, or Your Honor
Oh,
can
I'm so
just leave it
sorry.
as
Did
the
I just
sentence.
jump forward?
Not a problem.
Okay,
Not a
go
problem at all. State's recommendation is 12 months, serve 44 days, credit for time served 22 days, balance probated, total of an $800 fine, 300 on the hit and run, 500 on the driving without a valid license, a total of 60 hours of community service, 40 on the hit and run, 20 on the following too closely, and a driving course. That's all.
All right. So, well, this is awkward, but Ms. Robertson, did you agree to these terms?
Yes, I do.
All right. And Ms. Lewis, did you get those terms?
Yes, I did. Thank
All
you.
right, that will be your sentence. You will report to probation on Monday before 3 p.m.
And Judge, I
I'm like just off my pattern right now. I'm so sorry. Can I just do a brief do-over? Mr. Haddad, yes, sir.
Judge, I just want to let the court know, she has a felony hold still, so I'd ask the court to ask her to request or order that she report to probation within 24 hours or 48 hours of release.
Okay. Yeah. I'm so sorry. I just got a little off on I forgot to ask Ms. Falk to put the sentence. Ms. Robertson, you did plead guilty to hit and run, driving without valid license and following too closely, correct?
Ma'am.
Okay, and you understand that you'll be on probation, and from what I understand, you still have a hold at the jail, so you will report to probation within 48 hours of being released.
Okay.
All right, so once you're released, please make sure to report to probation on the first available business day. It has to be a Monday, Tuesday, or Thursday.
Okay.
All right, and of course, as Ms. Falk has already indicated, you'll be on probation to pay a $800 fine. You'll need to do 60 hours of community service, and you'll need to do a defensive driving class. Yes or no?
Yes.
Okay, all right. Okay, I think I'm back in sync. All right, thank you, ma'am.
Next is position 30, Mr. Rogers.
Oh, can I hold on Mr. Rogers for a second? I think I'm going back to Mr. Murphy's client, Ms. Pearson. And Judy Rosemary Pearson has already been advised of her rights. Her case number is 25 CR 4220Y. And I can't remember, but I'm going to place her under oath again. Ms. Pearson, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Okay, and we've already come to the same page about the plea offer, correct?
Yes,
Yes,
Your
Your
Honor.
Honor, we have.
All right, and Ms. Falk, what's the plea recommendation?
Yes, Your Honor, the state's recommendation on count 1, we are reducing that to disorderly conduct, 12 months, serve 86 days, credit for time served 43 days. Stay away from the MARTA 5-point station, no further contact with Lauren Battle. This remainder of her sentence will be suspended upon her release from custody. We do also agree to the remaining counts, which I believe are, let's see, counts 2 through 5 will merge with count 1.
So simple battery will also merge then because it was previously a consecutive charge.
That is correct.
Okay.
That is what was agreed to by SG Skates.
All right. Mr. Murphy, do you so stipulate to the factual basis, venue, and ID?
We do so stipulate, Judge, and as a housekeeping matter, I want to advise the court that I've met with my client personally several times, and we've gone over the plea forms, and she has authorized me to sign an initial where needed on the plea forms.
All right, that's acceptable. Ms. Pearson, have you consumed any medicine or alcohol recently?
No, Your Honor.
Have you understood what's going on in your case?
Yes, Your Honor.
And are you satisfied with your attorney?
Yes, I am, Your Honor.
If you decide to plead guilty to one charge of disorderly conduct, you would have to give up your right to a trial. You will not be able to go back to court to face your accusers, challenge the charges brought against you, present your own defenses and arguments, and the state won't have to prove the original charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I am, Your Honor.
How do you plead to one count of disorderly conduct?
Guilty.
All right, I'll accept your plea. Counts 2, 3, 4, and 5 will merge into count 1. On the disorderly conduct, your sentence is 12 months to serve 86 days, credit for time served 43 days, balance suspended, and to stay away from 30 Alabama Street, the MARTA station, until all suspensions have been lifted. Thank you.
Excuse me, Ms. Falk, can you please make sure that charge is adjusted in the system? If I can enter the disposition, it's not in there yet.
Understood. Yes, I will have to change the accusation on that. I will do that
Thank
today.
you.
Hopefully before the end of court.
Thank you. And
Oh.
Judge, I'll have that paperwork to you before 1 o'clock. I'll be down at the courthouse.
All right, thank you.
Just bring it to me.
And we'll be close.
Thank you. All right, thank you. Mr. Murphy, do you have any other cases or do you have a calendar at 11 o'clock?
Judge, I have position 35 Wilkins, and I needed to speak to Wilkins. That was a recent appointment.
Okay, thank you. All right, Rogers, was it at courtroom 2?
Yes, Your Honor, position 30.
Thank you. Ronzo Edward Rogers. His case number is 25 CR 4993Y, accused of simple battery family violence from August 16, 2025. Mr. Rogers, you've been advised of your rights and your attorney is Ms. Maureen McLeod. Ms. McLeod, good morning.
Good morning, Your Honor.
And how would you like to proceed?
This is going to be a non-negotiated plea.
Thank you. Mr. Rogers, in a non-negotiated plea, the prosecutor will give me a recommendation and then your attorney will give me an alternative recommendation. Based on the allegations set forth, your criminal record history, as well as the circumstances giving rise to these charges, I will consider the two options and let you know of my decision, at which point then you can decide whether you still want to proceed with the plea or whether you would like to enter a not guilty and have the case reset for trial. Meanwhile, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes, no?
Yes, ma'am.
Thank you. Ms. Falk?
Yes, Your Honor. Do you want pretrial to put his history on the record?
You could as well if you want to.
Okay. Yes, Your Honor. The defendant has, 50 cycles. The most recent offenses, my Odyssey is just taking a moment to pull up his GCIC in full screen. Okay. His most recent offenses are going to be a 2024 arrest for theft by receiving stolen property, driving while license is suspended. The GCIC doesn't show a disposition. A failure to appear in March of 2023. A conviction for entering auto criminal trespass in Fulton County Superior Court, and that plea was on November 13th of 2024. Let's see. A probation violation, that was in 2016. A parole violation in 2015. He had 3 years in prison for a theft by taking in 2013. That was out of Cobb County. Let's see. Another probation violation in 2013. So those are his most recent charges. He did also have an aggravated assault, armed robbery, possession of cocaine that was pled down to simple battery and theft by shoplifting in 2009. In this case, Your Honor, we have I may just take a moment to switch from our GCIC to the Documents tab. We did have an opportunity, just to let Your Honor know, to speak with Sequoia Taylor, who is the victim in this case. She is in agreement with the plea. We would like to sound for her in case she is present today in court, but I just wanted to put her perspective on the record as well. This incident happened August 16th of 2025 at 514 Sunset Avenue in Atlanta. Ms. Taylor and the defendant were living together at that location. They do not have children together. She said she was in a dispute with him over not buying him a pair of socks. She also stated he had been bothering her all day. And then later that night, as they began to argue, she was trying to leave the house and she stated he grabbed her around the neck and started choking her and then punching her in the mouth with a closed fist. She ran out of the front door of their apartment. He closed the door and locked it. She remained outside and waited for police to arrive before climbing through the front window to get back into her home. The defendant had fled the location through the back door prior to police arriving. We did do a strangulation assessment, and based on the strangulation assessment, we were not able to upgrade the charge. And so we are recommending 12 months served, 60 days, credit for time served 14 days from August 22nd, 2025 until today. Balance probated, no further violent contact with Sequoia Taylor. FVIP, 40 hours of community service and no firearms. We did again speak with Sequoia Taylor. She is in agreement with the plea, and she did request no further violent contact instead of no further contact. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this non-negotiated plea. That's all for the state.
We do, and I would also like to say that I believe Ms. Taylor is on because I spoke with her this morning.
All right, then we would like to sound for Sequoia Taylor at this time, Your Honor.
She was, and then she left.
Yes, Your Honor, I believe the court told her to put on a jacket or something. I don't know if she's in the waiting room.
Okay.
Oh.
Oh boy, so
I
it's
didn't
something
actually
you
see
said.
her. I
All
just
right.
heard when it was said. So I presume that was her because I had just spoken to her shortly before that. But the reason why this plea is non-negotiated, Your Honor, is the time. My client is trying to get out of jail. His mom died on Friday and he really wants to go to the funeral. I actually spoke with Miss Taylor and I asked her whether or not this was accurate. I just wanted to make sure. And she told me that that was in fact true, that his mom had died over the weekend on Friday. He just wants to get out so he can go to her funeral. He's okay with the other terms of the state's plea offer.
I'll accept the defense recommendation. And so basically you're asking to serve 28 days, credit for time served 14 days, right?
That is correct, Your Honor. Just to give him the opportunity to go to his mom's funeral.
Is he going to come back after?
No, Your Honor, just, to get in time to go to his mother's funeral.
We're actually okay with that idea if you want to do weekends.
No.
I just will point out that the victim, knowing his mother died, is still in agreement with this plea, Your Honor. And based on his history,
understand that she didn't know
if
that.
I may finish, Ms. McLeod, I would
Go
speak.
ahead.
And based on his history, we would ask that the recommendation of 60 days be followed, even if that is weekends.
No, I'm going to go with the 28 days, and he's going to be reporting to probation. And if he decides to violate the conditions of his sentence, then it's simply coming back to jail for the rest of the year. So it's either comply with probation or come back to jail for the rest of the year. I'm not going to have him go in and out of the intake department over weekends. So,
Yes.
Mr. Rod, so Ms. McLeod, I'm going to go with the defense recommendation. Essentially, it's pretty much going to be the same, except instead of reporting to jail, he'll be reporting to probation.
That is correct, Your Honor.
All right, and you so stipulate. Mr. Rogers, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in your case? I'm going to release you within 24 hours, and you must strictly comply with the conditions of your probation. Are you prepared to do that?
Yes, ma'am. Thank you, ma'am. Yes, ma'am.
And are you satisfied with your attorney?
We're certified, ma'am.
If you decide to plead guilty to this charge, you will have to give up your right to try this case in a court of law in front of a judge or a jury. You will not go back to confront your accusers, challenge the evidence brought against you, and the state won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to simple battery family violence?
Guilty.
Your sentence is going to be 12 months to serve 28 days, credit for time served 14 days. The remainder of the time will be on probation. I apologize. I'm sorry for the loss in your family, but you must report to probation on Monday before 3 p.m.
I
Do you
will.
understand?
I'll be there.
Okay. And while you're on probation, you are to have no violent contact with Sequoia Taylor. There cannot be any verbal altercations, no verbal arguments, and definitely cannot be any physical altercations or physical arguments. Otherwise, you're back in jail.
Yes,
for the
ma'am.
rest of the year.
I understand.
And
Thank-
within 30 days of being released, you must enroll in a qualified domestic violence program. This is a series of 24 classes, and you must complete each and every class without missing or skipping them at your expense. You're also required to do 40 hours of community service at any nonprofit agency that's not a church and not a school. And you must begin your community service in the first month at a minimum rate of 5 hours per month. At all times, you're not possess and have any firearms.
Yes, ma'am.
Thank you, Your Honor.
Mhm.
Thank you.
Thank you, Your Honor.
God bless.
All right, moving on. ACDC, who do we have?
This is gonna be position number 34, Mr. White.
Nathaniel Lamont White is accused of criminal trespass and loitering or prowling on August 7th of this year, case 25 CR 4976G. Mr. White, you've been advised of your rights, and your attorney is going to be Mr. Haddad. This is going to be am I correct? A plea? Okay. Mr. White, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Ms. Falk, what's the recommendation?
On Mr. White's case, Your Honor, position 34 on the criminal trespass, count 1, 12 months concurrent with count 2. On the loitering and prowling, 12 months served 90 days, credit for time served 28 days. From August 8th, 2025 until today, balance probated Operation 21 law and decision-making course and stay away from the Mix Apartments at 120 Piedmont Avenue in Atlanta, and 40 hours of community service. We do ask the defense to stipulate to venue factual basis on identification for the purposes of the plea. That's all for the state.
We stipulate, Judge.
All right. Mr. White, have you consumed any medicine or alcohol?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty to these charges, you would have to give up your right to a trial. You will not be able to go back to court to confront your accusers, challenge the evidence brought against you, and present your own arguments and defenses. The prosecutor also won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to criminal trespass and loitering or prowling from August
Guilty.
7th of this year? I'm sorry?
Guilty.
Your sentence is for the criminal trespass is going to be 12 months concurrent with count 2. And for the loitering and prowling is going to be 12 months to serve 90 days, credit for time served 28 days. You have additional time to serve at the Fulton County Jail, after which, if you are released, you will report to probation within 48 hours and the first available business day, Monday, Tuesday, or Wednesday. While on probation, you will enroll and complete the Operation 21 Law and Decision Making course. You will stay away from the entire apartment complex called Mix Apartments at 120 Piedmont Avenue in Atlanta, Georgia. You will also complete 40 hours of community service at any nonprofit agency, and you must begin your community service at a minimum rate of 5 hours per month. Thank you.
Next is position 25, Mr. Patterson.
Lazarus Patterson,
Yes, good morning, Lazarius Patterson, ma'am.
Lazarius Creshawn Patterson, correct? Ms. Tucker, is that correct name?
Yes, Your Honor.
All right. He's accused of criminal trespass under case 25 CR 4778E from August 14th of this year. Mr. Patterson, you've been advised of your rights, and your attorney is going to be Ms. Tucker. May I place you under oath for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Your Honor.
Thank you. Ms. Falk, what's the recommendation?
Yes, Your Honor. On Mr. Patterson's case, the recommendation is 12 months served, 44 days, credit for time served 22 days from August 14th, 2025 until today. Balance probated, a BHET, stay away from all Georgia State University premises and property, and 40 hours of community service. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
Ms. Tucker?
We do so stipulate, Your Honor.
Mhm. Mr. Patterson, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood what's going on in your case?
Yes, Your Honor.
Just one second. Shoot. This is balance probated, right?
Just give me a moment to get back to my place, Your Honor.
Yes, Your Honor. I believe it's due to the 40 hours of community service.
Well, I just want to be sure whether he has another active probation case from 23 CR 004720E. He took a plea in May of 2025. Is JCS present? He was required to do. We waived probation fees for 2 months. He was required to stay away from GSU. And I want to know whether that one was, he was supposed to do 40 hours of community service.
Judge, that's correct. That was a plea that was taken on the state all-purpose counter on May the 22nd of 2025 before Judge Mincy. And apparently he was already signed to do English management classes, and he's supposed to stay away from GSU.
JCS, has he completed these terms? Or probation, if they can report?
JCS probation, are you on the line?
I have a suspicion this is going to be another plea that's going to go nowhere.
Your Honor, do you want us,
uh,
do you want us to hold until JCS
No,
can report in?
Probation, JCS, this is Judge Lal, good morning. I'm inquiring about Lazarius Krishan Patterson, position 25. He's on probation in case number 23 CR 004720E. He was required to do anger management, stay away from Georgia State University. I don't know what else, but what's his, and he took this plea on May 22nd, 2025. What is the status of his probation? Because apparently he reoffended while he was on probation.
Hi, Judge. How you doing? I'm helping her out right quick.
All right.
Let's see.
Okay.
What's the defendant's name?
Krishan, I'm sorry, first name is Lazarius, Lazerrius, middle initial C, and last name Patterson, common spelling. Ms. Tucker, I'm going to have to revisit this case. He just took a plea in May and then he reoffended in August.
Okay, so he has not been in the office in July.
I'm sorry,
Or,
repeat?
You have not been in the August since the first time you've been. You know what? He's never been.
He's never
He had
reported?
never showed up. I'm sorry.
He's never reported?
No, ma'am.
Has he? I'm not going to accept this plea. He just took a plea in May of 2025 and he's completely violated it. And now I'm going to put him back on the same sentence? If the state or probation wants to file a probation revocation, that's perfectly fine. But we have a little conundrum over here. Ms. Tucker, how would you like to proceed?
Your Honor, if you're not willing to accept the plea recommendation from the state, then we will have to enter a waiver on his behalf.
I don't have I've never had any paperwork on anything. I don't even know what to do. I don't have any way to contact anybody. I don't have any paperwork. I've never received any paperwork on anything. I don't know who to contact. I've never received any paperwork. I don't have anything. I don't have any form.
Well, I can't take this paperwork, but I believe on May 22nd, 2025, Judge Regina Mincy expressly told you that she was accepting your guilty plea to criminal trespass at Georgia State University, and she read the sentence to you, at which point you were required to either go to the public defender's office or to the clerk's office and obtain a copy of your disposition. But you were expressly instructed to report to probation. So I'm not going to accept this plea offer because you are in violation of your probation from a prior case based on this current report. But it'll be still subject to revocation. Your bond remains the same. Ms. Tucker, do you have your client's consent to enter a waiver of arraignment?
I'm trying to speak with him now, Your Honor.
All right, then while you speak with him, we'll take the next case. I'll be glad to accept 12 months to serve. That's about all I'll accept, day for day.
Next is position 4, Mr. Blocker.
I have South Annex as well. Do we know who's there?
Yes, Your Honor.
Okay, as long as you know they're there. I just didn't want to think we're ignoring them.
No, ma'am.
Okay. All right.
Tucker's client is Mr. Murphy's client, and he's talking right now.
Okay, thank you. Alto Blocker's case is 25 CR 004-944Y, accused of theft by shoplifting and criminal trespass from August 20th, 2025. Mr. Blocker, you've been advised of your rights, and your attorney is going to be Mr. White. Understand this is also going to be a plea. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Judge.
Thank you. Ms. Falk?
Yes, Your Honor. The recommendation is 12 months served 32 days, credit for time served 16 days. Balance probated, stay away from the Publix at 1425-600 Market Boulevard in Roswell, an anti-theft course, and 40 hours of community service. On count 2, the criminal trespass, 12 months concurrent with count 1, stay away from that same Publix at 1425 Market Boulevard in Roswell. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Mr. White?
So stipulated, Your Honor, we just ask the probation terminator go non-reporting once he completes all of his requirements.
All right. Mr. Blocker, have you consumed any medicine or alcohol recently?
No, Judge.
And have you understood what's going on in your case?
Yes, I do.
And are you satisfied with your attorney?
Yes.
All right. And if you decide to plead guilty to these charges of criminal trespass and theft by shoplifting, you have to give up your right to a trial. You cannot go back to court to face a judge or a jury to confront your accuser, challenge the evidence brought against you, And also, the prosecutor won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I am.
How do you plead to criminal trespass and theft by shoplifting from August 20th at the Publix supermarket in Roswell, Georgia?
Guilty.
All right. On the theft by shoplifting, your sentence is going to be 12 months to serve 32 days, credit for time served 16 days.
Okay.
If you have no other holds, you will report to probation this Monday before 3 p.m. While you're on probation, you will stay away from the Publix grocery store at 1425-600 at Market Boulevard in Roswell, Georgia. Within 30 days, you will enroll and show proof of enrollment in the anti-theft class, and you will complete 40 hours of community service, and you will do the community service at any nonprofit agency that's not a church and not a school. And you must do your community service at a minimum rate of 5 hours per month, beginning in the first month. Do you understand?
Yeah.
Say it again, Mother.
On the criminal trespass, your sentence is going to be 12 months concurrent with count 1. Stay away from the Publix at the same location. And Mr. Blocker, yes, I do remember that you pled guilty to criminal trespass from the Roswell Summit recently in July before Judge Morrow. Do you remember?
Yes.
So you are going to report to probation every month. I hope probation is listening because we're going to watch your case very carefully.
Yes, ma'am.
If you reoffend again, or if you violate any of these conditions by not doing your probation, not doing your community service, not doing your anti-theft class, and not staying away, I'm going to order probation to revoke your probation in both cases and have you serve out the rest of the time in prison.
Thank you, Judge.
Remember, we don't forget. We might overlook sometimes, but we don't forget.
Okay, Judge.
All right, and I don't want to see you here again. So please remember to comply. Report to probation every month and keep up with your probation fees. Thank you.
Thank you, Judge.
That's it. Next, we can go to position 8, Mr. Davis.
I'm going to need to speak to him.
All right. Courtroom 2, Attorney Tom White needs to speak to Mr. Davis.
All right.
Judge,
Yes, Ms. Murphy?
I had a brief announcement on number 35, Mr. Wilkins.
Yes, sir.
Judge, if we can reset till Thursday,
Okay,
I'll go see him and then we'll decide what we're going to do.
sounds good. It's going to be reset to next Thursday SAP calendar. Today is the 4th, so that would be September 11th at 9 a.m.
Duly noted. Thank you, Judge. Appreciate it. That's all I have.
All right, so have a good weekend then. Take care.
And that's Mr. Wilkins' position 35?
Yes.
That's correct.
Icarius,
Thank you.
Icarius Wilkins.
Hello.
Shall I go to South Annex Courtroom 2 or should I wait?
No, Your Honor, they're on the phone right now. We can go to position 20, Mr. Holloman.
Okay.
So you decided to take this, you wouldn't have information there.
Mr. White, have you spoken to Mr. Holloman? Attorney, Tom White's talking to his client.
Right, he's talking to his client.
Oh, Holloman is also represented by Mr. White.
If you don't.
Is PD Haddad free?
He asked if he could speak with Davis,
Oh,
but, can you call him on the?
yeah.
Forum 2, Mr. Holloman is represented by attorney Tom White, so he's unavailable to take this case right now. I'm not sure where Mr. Haddad is.
Judge, I'm here. The issue is that Mr. White had discussions with both defendants already, yesterday and, you know,
Okay, no problem. Do you have any clients that need to be addressed?
no, Judge, I've resolved all my cases, Judge.
And what about Ms. Tucker?
She's on the phone right now with, South Annex, Judge.
Okay, all right, we will resume with one of your cases as soon as they're available, okay? All right, thank you. I have a bench warrant. Matter, let's see, Alan Lewis is scheduled to come at 11 o'clock, so we are still a little early. So
I did see him on the line, Judge, but I don't see him no more. He was earlier.
is there a way to reach him to see if he's available? Maybe Mr. Haddad can speak with him?
Well, I guess we could try to contact him.
Mr. Haddad, this is our,
TV, I
yeah,
I-
motion.
can have a phone number for him, and I'll reach out to him,
Okay, all right, we'll be in a brief recess while we're waiting. South Annex is the individual speaking to their attorney? Deputy at South Annex?
Yes, they speaking to Ms. Tucker.
Okay, all right. And we'll be in a brief recess until one of the cases is available. Thank you.
Your Honor, we're ready for, the individuals at South End.
Okay, thank you. Oh, all right, there we go.
I do have an announcement on those. For position 37 and 38, with Mr. Denard Wilson, I'll be entering a waiver on his behalf.
That was Denard Wilson, right, with the D?
Yes, Your Honor.
All right. So Denard Wilson will be entering a not guilty plea. It's going to be a waiver of arraignment. And the case is going to be further notice for jail jury. All right. Any other announcements, Ms. Tucker?
Yes, I did speak with position 32. And whenever that's called, we'll be asking for a bond hearing.
All right, Jacob Stewart. All right. What's his current bond?
That case was transferred over to state court, so there's not been a bond set as of now.
All right. Let me see. Is he present in the courtroom?
Yes. Oh, well, they'll have to grab it, but he is here.
All right, this is case 25 CR 4954F. And as soon as he's seated next to you. All right, Mr. Jacob Stewart's accused of possession and use of drug-related objects from August 8th, 2025. Case number 25 CR 4954F. I understand that Mr. Stewart's original charge was transferred from the Superior Court. Does he still have the aggravated assault charges in Superior Court?
Yes, Your Honor.
Okay. All right. And Mr. Stewart, you've been advised of your right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Ms. Tucker is representing you. Ms. Falk, do you have a bond recommendation?
No, Your Honor, quite frankly. The reality of it is, if the defendant gets a signature bond, the time he will serve on this will stop. And so any recommendation would not include time served. So we're fine with a signature bond.
It'll be a $500 signature bond through the jail. No illegal drugs, no alcohol, and no weapons and no firearms. No illegal drugs also means drug-related objects. And your felony case, well, good luck with that. Thank you. All right. I guess we're still waiting on our DB case and Mr. White. And I guess we'll be back in a recess. No one's ready yet.
We're ready, Your Honor. South Annex, do you have Mr. Smith available?
He was there 2 minutes ago.
No, no. All right, Your Honor, we can go to position 36, Mr. Wilson.
Okay. Brandon Moore Wilson's accused of criminal trespass from August 20th, 2025. Mr. Wilson, you've been advised of your rights, and your attorney is Ms. Tucker. This is case 25 CR 4943G. Mr. Let me see. May I place you under oath for this plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Right? Ms. Falk, are you available?
I didn't realize I had my camera off. Yes, on the criminal trespass, 12 months served 32 days, credit for time served 16 days from August 20th, 2025 until today. Balance suspended, stay away from Midtown Village located at 140 Pine Street Northeast in Atlanta. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
We do so stipulate, Your Honor.
I hate to be a pain, but what's the current status of his probation in 25 CR 003118G? He took a plea on June 26, 2025. He's supposed to be on probation. This new offense occurred while he was on probation. JCS, if you could please respond. Probation, JCS?
Yes, Judge.
Yeah, good morning again. We have
Good morning.
another matter. We have position 36, Brandon Moore Wilson. Case number 25. Well, probation, your case number is 25 CR 003118G. He took a plea on June 26, 2025. To complete certain requirements, he was charged with PI and giving false information. Has he reported and begun with the conditions?
What's his last name?
Wilson, WILSON. First name Brandon, middle name Moore, MOORE.
You say Brandon, that's the first name?
Brandon is the first name.
We don't have a, and the middle name was Moore?
Yes.
What would be his, do you have his date of birth? Well, you don't have that.
Date of birth, January 28th, 1990.
Okay, hold on 1 second. You said January what now?
Repeat this question.
JCS, I put it in the chat for you just to help out so that you have all the information you need.
Okay, 1 second.
Okay.
Okay, Judge, no, this is Ms. Thomas again. He's been they have been checking every day to see if he's been in custody, so he is not reported yet.
He is not reported at all?
No, because they've been checked, so we haven't been checked custody. They had him in jail status, and they've been had him in jail status since January the 2nd of January 2025, and it's been going on all this time up to 8/11 that he's in custody.
He was released on August 13th. Okay, so he didn't report after he was sentenced on August 13th, 2025, and he got rearrested 7 days later on this trespass charge. Okay, understood. Thank you.
You're welcome.
Thank you very much. All right. Miss Tucker, I will accept this plea offer as long as he understands that he's on probation for 2 cases.
We're prepared to proceed, Your Honor.
All right. Mr. Wilson, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in both your cases?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
Are you going to enter this plea freely, willingly, and knowingly?
Yes, ma'am.
And if you decide to plead guilty to this case, you would have to give up your right to a trial. You won't go back to court. You won't face a judge or a jury. You won't face your accusers. You'll also not be able to challenge these charges in a court of law and present your defenses and arguments, and the state won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
You understand that you'll be on probation for 2 separate cases, and if you violate those conditions, I'm going to revoke your probation and you'll be serving time for 2 cases.
With this case, the balance was suspended, Your Honor.
Oh, I'm sorry. Okay, so you'll be serving time on the QT case.
I did explain that he is currently on probation. He is required to check.
Okay, for the other case. All right. So are you prepared to plead guilty to criminal trespass?
Yes, ma'am.
How do you plead?
Guilty.
Your sentence is 12 months to serve 32 days, credit for time served 16 days, to balance is suspended. And this one, you have to stay away from the entire Midtown Village at 140 Pine Street in Northeast Atlanta. I know exactly where that place is, and I hope you do, because you cannot be seen within 200 yards of that location. Do you understand?
Yeah.
You are going to report to probation on Monday before 3 p.m. And that is for case 25 CR 003118G. If you don't report, I hope probation is listening, because I want to see a motion to revoke your probation and a probation warrant, which means that you spend the rest of the year in jail for that other case.
The rest of this year?
Rest of 12 months. You'll be in jail for up to 12 months.
Yes, ma'am.
Unless you just want to do the 12 months today.
No, ma'am.
So probation, you have a date on Monday before 3 p.m. It's at 132 Mitchell Street. If you don't show up, you're in trouble. And stay away from the QT gas station. Thank you. All right, next case. Mr. Are you ready to proceed?
You can go to position 22, Mr. Johnson.
Okay. Melvin Johnson's accused of 2 counts of criminal trespass from August 14th of 2025. His case number is 25 CR 4957B. Mr. Johnson, you've been advised of your rights. Your attorney is Ms. Tucker. And is this going to be, a plea?
Yes, Your Honor.
All right. Mr. Johnson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Folk?
Yes, Your Honor. On Mr. Johnson's case for count 1 of criminal trespass, 12 months served 28 days, credit for time served 14 days from August 22nd of 2025 until today. Stay away from 12990 Cogburn Road in Milton, Georgia. 40 hours of community service and a social worker visit. Count 2 will merge with count 1. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
We do so stipulate, Your Honor.
There is a petition to revoke his probation in case number 25 CR 001-386J. Has that been addressed?
It has not, Your Honor. Not to my knowledge.
All right. Ms. Lewis, we're gonna have to schedule this case. Who handles the probation? Is that gonna be with Judge Besson?
That case is assigned to Judge Besson.
All right. Since we're not doing the revocation calendars, those will be addressed by Judge Besson, correct?
Correct. She does her own probation revocations.
All right. I'm going to defer on this plea offer until the petition to revoke his probation in 25 CR 001-386J is addressed.
Judge, that was already done. It was, he already went before Judge Besson. It was just filed in on that day. It was filed in on July the 30th.
So she's already made a ruling on that
Yeah,
petition?
she made a ruling on it. He has to report October the 22nd in court. If not complete, English management or reporting. If he doesn't report by then, his balance will be revoked. So
Okay.
give him a second
right.
chance. I remember him because I was in court that day for that.
Okay, thank you.
Filling in for Aisha.
All right, so he's to continue on probation then.
Correct. He's to continue on probation.
All right,
To
got it.
October 22nd to get together.
Okay. All
Wait,
right.
yeah. So I am a little confused because this says July 30th, 2025.
Right, I think they filed the petition and the disposition on that day. So if you pull up the document, it actually shows Judge Besson's disposition.
Right, but our offense was August 14th, 2025.
Correct.
So that was after his probation revocation. So I guess what I'm trying to, my understanding was we were talking about a probation revocation because of this new case, not because of something prior to this new case.
No,
Am I making
there
sense?
was, understood, there was a probation revocation hearing in the prior case. Apparently, he did not comply with the terms of his probation, but Judge Besson has ruled on that. But the petition and the disposition was filed on August 1st, although it was taken
Okay.
before. So now, while after the revocation disposition, he has been arrested again on this case.
Correct. So
All
I think what I'm trying to understand is, will that trigger a new revocation petition?
If you want to.
It's not what
It's
I
what
want.
I call.
I'm just checking in. I'm just trying to make sure I understand the complete scope. Okay.
Yeah.
State's ready to proceed. We're fine with our recommendation.
All right, as long as we understand. Ms. Tucker, do you understand that pursuant to this new arrest, he is in violation of his probation in the prior case?
Yes, yes.
All right. All right, Mr. Johnson, have you consumed any, I'm sorry, did the state allocute already?
Yes, Your Honor, we did.
Okay, so Mr. Johnson, have you consumed any medicine or alcohol?
No.
And have you understood what's going on in your case, this new case?
Yes.
And are you satisfied with your attorney?
Yes, ma'am.
And have you understood that if you decide to plead guilty to this new 2 counts of criminal trespass, you would have to give up your right to a trial? You will not be able to confront your accusers, challenge the evidence brought against you, and be able to have the state prove the charges beyond a reasonable doubt. Are you prepared to give up these rights? Well, yes or no?
Yes.
All right. And how do you plead to these 2 new charges of criminal trespass?
Guilty.
Your sentence is going to be for count 1, 12 months to serve 28 days, credit for time served 14 days, balance probated. This is your second probation case this year. You will report to probation on Monday before 3 p.m. You will stay away from 12990 Cogburn Road in Milton, Georgia. You will complete 40 hours of community service at any nonprofit agency. And that will be done at either any nonprofit, but it cannot be done at a church or a school. And you will report to probation every month. Do you understand?
Yes.
You will pay your probation fees, and if you get arrested again, probation is authorized to issue another probation warrant. Do you understand?
Yes, ma'am.
Count 2 will merge into count 1. You will also continue to comply with your probation in case number 25 CR 001386J. And if you don't comply with that, you are also providing the state legal basis to have your probation revoked in both cases and serve out the time in jail. How many probation cases do you have?
2.
2. And when do you report to probation?
Monday before 3.
All right. If you forget, that's on you. Thank you.
All right.
Next is position 21, Mr. James.
Judge, before you get started on that case, for the last one, are y'all still requesting an SW visit?
The state is, yes.
Do we need one?
Your Honor, based on the facts of the case, that's why I think between the facts of this case and the previous case, I think that's why the state recommended one. But if Your Honor doesn't feel one is warranted,
No,
that's
he
fine.
knows. I think he knows what he's doing. If he doesn't, well, we'll do this all over again. Okay. This is Odell James, accused of driving on a suspended registration and willful obstruction of an officer from August 7th, 2025. Mr. James, you've been advised of your rights and your attorney is Ms. Tucker. This is going to be a plea. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Falk?
Yes, Your Honor. On Mr. James's case, the knowingly driving on suspended registration, 12 months served 56 days, credit for time served 28 days from August 8th, 2025 until today, balance probated and a $500 fine. On count 2, the willful obstruction of an officer, 12 months concurrent with count 1 and a $300 fine. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea, and that's all for the state.
We do so stipulate for the purpose of the plea, Your Honor.
But he's not going to be released, right? He still has another bond, or has he posted bond in the other case?
He hasn't posted bond in the other case, but I have discussed that with him. He's aware that he'll still be in custody.
All right, and he understands he's got a Houston County hold.
Yes, we've discussed that as well.
Okay. Mr. James, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty, you would have to give up your right to a trial. You will not be able to challenge these these 2 charges in a court of law before a judge or a jury. You will not be able to confront your accuser, present your own defenses and arguments, and the state won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to driving on a suspended registration and willful obstruction of a law enforcement officer?
Guilty.
Your sentence for the suspended registration is going to be 12 months to serve 56 days, credit for time served 28 days, balance probated. You would need to pay a $500 fine for this charge. On the willful obstruction is going to be 12 months concurrent with count 1, and you'll need to pay a $300 fine. If you pay off your $800 fine and all probation fees, then your probation will be non-reporting. No driving unless you have a valid driver's license, adequate insurance, and proper registration. So before you start any car, make sure you check with the Department of Driver Services that your license, your insurance, and your registration are all valid. Otherwise, no driving.
No.
And as you know, you are still in jail on a pending felony case, and you also have a Houston County hold. So once you've resolved all these holds, then you'll report to probation within 48 hours for this case.
Yes, ma'am.
Thank you. Good luck.
Next is position 28, Mr. Reed.
Jason Reed is accused of public drunk from August 22nd, 2025, in case 25 CR 5004B. Mr. Reed, you've been advised of your rights. Your attorney is Ms. Tucker. And Ms. Tucker, this is going to be a plea?
Yes, Your Honor.
Okay. Do you solemnly swear and affirm, Mr. Reed, that the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, I do.
Thank you. And Ms. Falk?
Yes, Your Honor. State's recommendation is 12 months served, 28 days. Credit for time served 14 days from August 22nd, 2025 until today. Balance probated. Stay away from 2565 Old Milton Parkway in Alpharetta, ADET, and 40 hours of community service. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
We do so stipulate for the purpose of the plea, Your Honor.
All right. Mr. Reed, I'm going to require an imposition that you be subject to random screens for alcoholic beverages and illegal drugs. So in addition to the conditions, this is what I'm going to impose. Do you still want to proceed with the plea?
Yes, ma'am.
You understand that you've got open DUI cases as well.
I do not have any open DUI cases.
Pre-trial, Ms. Washington?
Yes, Your Honor.
Are there any DUI cases open or otherwise disposed of?
And this is Mr. Reed.
Yeah.
Give me one moment. I see a hold from Arkansas for a fraud case from 2022. In Miami, in Florida, there appears to be a recent arrest from August 9th of this year for alcohol beverage curb drinking. So I'm not sure if that is a technical DUI.
That was reported at first appearance. So is there a mistake in his GCIC? Ms. Falk, do you have anything on GCIC?
I'm pulling it up now, Your Honor. Jason Reed.
There was also an arrest in March of this year for drunkenness in public out of Missouri. But it lists no disposition. So the cases may still be pending, but it has no disposition. So it could very well be still open.
Okay. So you don't see, all right. So then it's not a DUI cases, it's just significant issue with alcohol.
Correct. I do see DUI arrest.
All right. Do you concur, Ms.
Actually, well, I mean, it's old, but we have a history pretrial. Are you showing a history out of Missouri? Or, okay, let me see.
Never been to Missouri.
I'm sorry, not Missouri. I'm sorry.
My
I'm reading the letters. Mississippi.
Right, correct.
My
yes.
apologies.
So that was what I was referring to was Mississippi.
Yeah, DUI third or subsequent conviction in cycle 2.
Correct.
5 years supervised probation. Then a 2015 arrest for first DUI offense. That's going to be cycle 4. I'm not showing a disposition on that one. And then that 2015 profanity, drunkenness in a public place, 2016 DUI second conviction, arrest, not showing a disposition, motor vehicle violation, DUI second conviction, failure of owner or operator of motor vehicle to maintain liability insurance card, and careless driving.
Okay.
So I think those are, and then
they were convictions.
Yeah, and then a 2021 arrest for first DUI offense. I don't know why first, it's the third arrest, disorderly conduct and false information or identification given to a law enforcement officer. But none of them are showing, Your Honor, any kind of disposition, just arrests.
Okay. All right. So back to my original question. Mr. Reed, I'm going to require you to report to probation every month, and you will be subject to random screens. Would you still like to move forward with this plea?
Yes, ma'am, I would. And if I may speak, I have,
Speak about what?
I'm sorry, she said something about a hole in Arkansas that's already taken. My attorney advised me to just, sit back and listen.
Good advice. All right. And Ms. Tucker, you do stipulate, right?
Yes, Your Honor.
All right. Mr. Reed, have you, well, I hate to ask this question, but have you consumed any alcohol or medicine recently?
No, ma'am, not in the past 14 days, definitely.
And let's keep that as a track record. Do you know what's going on in your case?
Yes, ma'am, I do. I have agreed to, with you to take drug screenings, and I will be credited time served. I will be released in the next 24 hours, and you will further enlighten me.
Probation.
Oh, yes, ma'am, and probation, you will give me the stipulations and all now as I sit back and listen.
Are you satisfied with your attorney?
I am.
If you decide to plead guilty to this charge, you will have to give up your right to a trial. You will not go back to court to face your accuser, challenge the evidence brought against you, be able to present your arguments and defenses in a court of law, and the prosecutor won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to public drunkenness?
I plead guilty.
Your sentence is going to be 12 months to serve 28 days, credit for time served 14 days. The remainder of the time you will be on active probation for the rest of the 12 months. You will report to Fulton County Probation on Monday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. At all times, you will stay away from 2565 Old Milton Parkway in Alpharetta, Georgia. Within 10 days of being released, you will submit yourself to an alcohol and drug evaluation with a healthcare provider, and you will submit yourself to all treatment and counseling that's required, including enrollment in AA or any other similar program. And you will actively participate and attend all these classes if required. You will complete 40 hours of voluntary community service at any nonprofit agency, and the community service must be done at any nonprofit agency, but it cannot be a church and it cannot be a school. And you must do your community service at a minimum rate of 5 hours per month. As I've already also directed, you are not to consume any alcoholic beverages, and you're not to consume any illegal drugs. You will be subject to screening by probation. And if you fail a screen, probation is authorized to issue a probation warrant, and you'll spend the rest of the 12 months in Fulton County Jail. Thank you.
Thank you, ma'am.
Next is position 8, Mr. Davis.
Your Honor, this will be a non-negotiated plea.
All right, sir. Derek Davis is accused of criminal trespass and willful obstruction of an officer from August 22nd, 2022 of this year. Case 25 CR 4986E. Mr. Davis, you've been advised of your rights, and your attorney is going to be Mr. Tom White. This is going to be a non-negotiated plea, which means that the state is going to give me a different recommendation from your attorney. Before you accept any plea, I'll let you know which option I'm going to select. May I place you under oath for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
Thank you. Ms. Falk?
Yes, Your Honor. The state's recommendation on this case is going to be 12 months served 60 days, credit for time served 14 days. That is from August 22nd, 2025 until today. Balance probated. Stay away from 1044 Sim Street in Atlanta. No further contact with Miss Beverly Chandler. On count 2, 12 months concurrent with count 1 and a $300 fine. Your Honor, on this case, and if Your Honor could get from pretrial services the history, and I can give you the facts of this case.
All right. I understand he's got 17 cycles and a 2024 FTA. Is there something else you want me to highlight?
No, Your Honor. So this incident happened August 22nd of 2025 at 1044 Sim Street Southwest in Atlanta. Officers were dispatched there. They spoke to Miss Beverly. Her full name is going to
Chandler?
be, yes, Beverly Chandler. And she stated that the defendant was presented with legal paperwork indicating he had been evicted on July 10th of 2025. The officers made multiple attempts to get Mr. Davis to come out of the house. He failed to comply. He ended up barricading himself in the house. The Atlanta Fire Department, along with other units, had to arrive. And it took approximately 2 hours for them to make entry into the home and place Mr. Davis into police custody. And what was noted in the warrant was the police department had been dispatched to that location over 10 times in the last month in regards to the ongoing eviction situation regarding Mr. Davis. Of particular note, Your Honor, was that I believe Mr. Davis had entered a plea recently to a criminal trespass at a different location, which was under case number, let me just pull that up really quickly. That was, he received in January of this year, 60 days to serve on a different criminal trespass obstruction of a law enforcement officer. That sentence was under 25 CR 0000145H. And that sentence was given by Judge Morrow on January 28th of 2025 with a stay away from 451 Mary Street Southwest and no further contact with Davy Collins. So given the situation, as I explained to PD White when we discussed the case, I could not see my way clear of making a recommendation less than his previous recommendation. That's all for the state.
Thank you. Mr. White?
Your Honor, Mr. Davis is just asking that he time served be the sentence with all of the probation conditions remaining in place. He says that he has paperwork that shows that he's legally at the residence. Obviously, we can't provide that with the court today because he would not have been brought to jail with that. But nevertheless, he's still willing to plead guilty if he can get a time served offer, Judge. Like I said, we'll stick with the probation and all of the requirements within probation.
He was just released on March 12, 2025, and under the circumstances set forth, that was the reason why I issued a surety bond as opposed to a signature bond.
I understand.
So I'm more inclined to go with the state's recommendation. I don't see any mitigating factors to allow him time served at the present circumstance when he took a plea just earlier this year.
I understand, Judge, and the mitigating factor would, like I said, would be the fact that he says he has proof that he is legally in the home. So
that's fine. But the holdup, the fact that the police were there for over 2 hours while he barricaded himself allegedly, no. So that's what I mean by the basis of the surety bond. If he wants to challenge the eviction, it should have been done in a court of law and where he can present his documents rather than setting it up in this manner. So, yeah, I'm still inclined to go with the state's recommendation. Mr. Davis, you have a right to remain silent. Anything you choose to say in open court, your statements can and will be used against you. But if you want to waive your right to remain silent, that's between you and Mr. White.
Did you want to accept the offer as is with the 60-day sentence, Mr. Davis, or plead not guilty?
Yes, Your Honor, I just want to know that I've lived at that residence for 5 years. I have tax documents. I believe that.
All right, then I will refuse the plea, take the plea. Your bond is right now 2,250. And once you go to trial, make sure you present those documents.
There's a misunderstanding. I ain't taking the plea. I am taking the plea.
I'm sorry?
I'm taking the plea. There's a misunderstanding. I will take the plea, Your Honor.
If you are taking the plea, that may jeopardize a civil matter for you.
I understand.
We discussed that at the jail yesterday as well, Judge.
All right, so if you take the plea, you'll have extra jail time. You'll be admitting that you trespassed at the property, that you're not a legal resident, and that will jeopardize any claims that you have any kind of tenancy at the property.
When you say extra jail time, is it?
Yeah, that's extra jail time. They're asking for 12 months to serve 60 days, credit for time served 14 days. So how many more days does he have?
16, Judge.
16 more days.
Yes, Your Honor, I'll take it.
If you want, I can reset your case one more week and it will count towards the additional time and you can talk to your attorney about your legal options.
And 60 days will still stay in effect after a week.
Oh yeah, next week, it will just be the 16 days and we'll take into credit the additional 7 days you'll be in jail. But I want to make sure that you understand what your legal options are before you just jump and take this plea.
Yes, I'd like to do that, Your Honor, yes.
So are you asking for a reset?
Yes, ma'am. Yes, Your Honor.
Okay. We're going to
Davis.
set it to September 11th. Please understand your legal options.
Judge, if I could have 1 minute.
Yeah.
We have exhausted, I'm just explain to Mr. Davis that basically we have discussed everything that I can help him with. And if he wants to accept the plea, he might as well do it today. Nothing's going to change in the interim. But certainly, if you still want the reset, we can do that.
I would like to reset.
I'm sorry?
Yes, I would like to reset, Your Honor.
Okay, we'll see you on the 11th then. Good luck.
Next is position 20, Mr. Holloman.
Your Honor, this will also be a non-negotiated plea.
Okay, sir. Reginald Lamont Holloman is accused of simple battery, family violence, and possession and use of drug-related object from August 22nd, 2025. Case 25 CR 4995D. Mr. Holloman, you've been advised of your rights and your attorney is Mr. White. May I place you on the oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes or no?
Yes, ma'am.
Thank you. Mr. Holloman, I'm going to hear first from the state as to their recommendation, and then I'll hear from your attorney, and I'll let you know what my decision is with regards to which option I will elect, and then you can decide whether you want to move forward with the plea. Ms. Falk?
Yes, Your Honor. The defendant in this case has, well, previous to this case, he had 21 cycles. On our current case, this incident happened August 22nd of 2025. Johnny Duncan stated that the defendant attacked him. He stated that he advised that the defendant would need to leave as soon as because Duncan's daughter was coming to stay at the residence for a few days. Duncan and Holloman then got into a verbal dispute. Mr. Duncan said he separated himself and went across the street to his friend's house, Miss Burns. They were sitting outside when the defendant stormed over, screaming profanities, and began striking Mr. Duncan with an open fist to the back of his head, causing his glasses to fall off. He stated Miss Burns concurred that she witnessed the altercation and called the police at 8:45 p.m. on that date. The defendant then stormed off. The officers did attempt to speak to the defendant, but he did not wish to answer any questions. He was then placed into custody at that time. And when he was explained that he would be placed into custody, he yelled, "Oh, since everyone is lying, then he hit me too." He also had a pipe on his person, which was consistent with cocaine use in his shorts pocket. It had burn marks and burn residue on the pipe. We will say that the defendant's history is, as I said, 21 cycles. We do have criminal trespass, most notably is a 2014 aggravated assault where he received 5 years with 2 years to serve. And prior to that, looks like an FTA, and then prior to that, a robbery conviction, and I know this is remote, but from 2003, where he received 7 years in prison. So that was the basis of the state's recommendation based on his history, which included violence. That's all for the state. And we would like to sound for Mr.
Johnny Duncan?
Johnny Duncan, if he is present here today, Your Honor. That's all. Oh, I will say, I apologize. We did have an opportunity to speak with him. He said he is okay with the plea. However, he does want a stay away. He did say the address was 380 Martin Street. It was Rawson Street where the incident happened, but Martin Street is where his actual residence is. And he also said the defendant will need a one-time law enforcement escort to retrieve his belongings.
Thank you. Mr. White?
Your Honor, our same request as the last case, that we are asking that it be a time served with the probation and all of the requirements of probation to stay in place. And again, with the stay away from the new address. Mr. Holloman does claim that he has defenses. He did not actually strike Mr. Duncan, but he thinks it's in his best interest to go ahead and enter a plea of guilty. He is involved in a CDC study that he has to report and provide a sample from, and if that does not occur in the next week, he'll be removed from the study, and we're just asking that you consider him for time served. The last violence was 11 years ago, from what I understand from the state. So,
all right. I will accept the defense recommendation as long as Mr. Holloman understands that he's to have no further contact with Johnny Duncan, and he cannot live with him at 380 Martin Street, and he's required to stay away from that location completely. He'll be allowed a one-time visit with a police officer to retrieve his belongings. That visit cannot exceed 1 hour. If he's in acceptance of these conditions, I can proceed with the plea. Courtroom 2, please unmute. Mr. Holloman, did you understand the court's requirements?
Yes, ma'am.
And are you prepared to stay away from Mr. Duncan and the Martin Street location?
I already have my belongings removed from that location.
So no reason to go back?
No reason.
Okay, so I'll remove the one-time visit. Do you so stipulate, Mr. White?
we do, Judge.
Mr. Holloman, have you consumed any medicine or alcohol recently?
Some for anxiety.
Okay, that's okay. And after consuming that, are you still able to understand what's going on in your case?
Yeah, I understand it. But I don't.
And are you satisfied with your attorney?
No. No.
I'm sorry, could you explain?
Ma'am, but I still like to see with it, because I don't feel like it's going to get any better know it, so.
I'm sorry, I didn't understand what you said.
No, I'll agree with him. But I want to proceed with this case anyway. I want to get it over with.
So you're not satisfied with your attorney?
No, ma'am.
Okay, you believe that you should consult and get an other advice?
It's that easy, so I ready to go and get it over with.
Okay, so we'll reset the case to September 11th, and perhaps another public defense attorney will speak with you and provide you maybe with a view that you agree with, and then you can decide how you want to proceed with your case. Thank you.
Judge, he can't forum shop in the office. I mean, if the judge wants to assign a conflict attorney to him, he can do that. We can do that, but
Okay, I'll do that. I
Okay.
mean, if he's not happy with the public defender's office, I will appoint Mr. Dennis Murphy to represent him. Mr. Holloman, another attorney by the name of Dennis Murphy will speak with you. And at that time, make sure you explain your grievances with him so that he perhaps will give you advice that with which you'll be satisfied. Thank you.
Your Honor, we can go to position 31, Mr. Smith at South Annex.
All right, Deputy at South Annex, thank you for being so patient. Is that Jared Smith with you?
Yes, ma'am.
Thank you, sir. Case number is 25 CR 5003F. Mr. Smith is accused of disorderly conduct from October 10th of 2023. And Mr. Smith, you have a right to remain silent about the facts of your case. Anything that you choose to say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you at the present time is going to be Ms. Tucker. Do you see her on the screen? Please wave your hand. Do you see her on the screen? Okay, good. Ms. Tucker, how are we proceeding?
This will be a negotiated plea.
All right. Mr. Smith, please raise your right hand for the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Falk?
Yes, Your Honor. State's recommendation is 12 months served 2 days, credit for time served 1 day from August 23rd, 2025 until August 23rd, 2025. Balance suspended, stay away from 1001 Virginia Avenue, which is Piedmont Urgent Care, unless for medical treatment. My understanding is the defendant is being held on other charges that the state cannot resolve as they are. It's not our venue. So we do ask the defense to stipulate to venue factual basis and identification for the purposes of the plea.
We do so stipulate, Your Honor.
Mr. Smith, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in this case?
Yes.
Are you satisfied with your attorney?
Yes, ma'am.
If you decide to enter this plea, you would have to give up your right to a trial, to go back to court to face your accuser, challenge the evidence brought against you, and the state won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of disorderly conduct at the Piedmont Urgent Care?
You said, how do I plead?
Yes, sir.
I don't really.
Have you spoken to your attorney?
You said who?
Have you spoken to your attorney, Ms. Tucker?
Yes, ma'am.
All right. Would you like to speak with her to decide how you would like to plead?
Yes.
All right, Ms. Tucker, please give him a call.
What she mean?
Well, what I mean is, are you pleading guilty to this charge and accepting the recommendation, or are you pleading not guilty and you want a trial?
I don't want no trial. I just want the 12, I want to go against.
So if you want to plead guilty, then you're admitting to the crime and you're going to be sentenced. So have you spoken to your attorney about that?
No, I haven't.
Okay, no problem. No problem. She will call you
right now.
Yeah, you talk to her and make sure you understand what you are agreeing to, okay?
Yes.
All right. Thank you. Deputy at South Annex, please mute the screen. Thank you. Thank you. We have, do we have another case in courtroom 2, or I can proceed with my
case is on there. He's on there now, Judge.
All right, Alan Lewis, please start your video and unmute. Alan Lewis, this is Judge Law. You'll need to start your video and unmute your screen.
Good morning, Your Honor. I represent Mr. Lewis. Mr. Lewis is physically in court in Clayton County. Is it possible for you to give him a second so that I can contact him and let him know that you're calling his case now?
Oh, that'd be fine.
Okay, thank you, Your Honor.
Who's handling the competency calendar? Is that going to be Mr. Bartel? I thought he was off today.
That's gonna be me, Judge.
All right. As soon as we are done with this, we'll go into a breakout to do that calendar, okay?
Sounds good, Judge.
Ms. Tucker, are you ready to proceed with Jared Smith?
Yes, Your Honor.
All right. Okay, Mr. Smith, we're going to resume with your case 25 CR 5003F. I believe the last question I was asking you was, how do you plead?
Oh, I plead guilty.
I'll accept your guilty plea. Your sentence is going to be 12 months to serve 2 days, credit for time served 1 day. That concludes your jail time. Is balance suspended? If understand that you have other matters that are holding you in jail.
Yes, ma'am.
Once you are released, you cannot return to the Piedmont Urgent Care Facility unless you have a specific appointment with a healthcare provider like a doctor or a nurse, or if you're seeking emergency health treatment. Do you understand?
Yes, ma'am.
You just can't stroll in.
Yeah, okay.
Right. That concludes your case. Thank you.
All right,
Some units, thank you so much for your patience. Y'all have a good day. Thank you.
Yes, ma'am. You too.
All right, Mr. Alan Lewis, please unmute. Mr. Lewis, can you hear me? Alan Lewis, can you hear me? All right, Mr. Alan Lewis, can you hear me? All right, Mr. Lewis, you'll need your speakers and your microphone connected to your Zoom.
He's connected. He may not have his volume up, but we heard him. We can hear him.
All right, Mr. Lewis, can you hear me?
What can I hear? What can I hear?
We can hear you, Mr. Lewis. I don't know what he does. We can hear him. Apparently he can't hear us.
Yep. Miss Pat, were you able to reach him?
Yes, Your Honor. I spoke with him right before he turned his camera on. And then I just texted him along with everyone else's chat messages. He's saying he can't hear. And I told him to turn the volume up. He says he's going to leave and come back.
That would be the smart thing. Okay. All right. Let's see now. Mr. White, have you addressed all your clients?
I have, Your Honor.
And Ms. Tucker, have you addressed all your clients?
He has, Judge.
Okay. let's go ahead. Position 1 and 2 were pleas. Position 3 was a null pros. Position 4 was a plea. Position 5 was a waiver of arraignment and further notice jail jury. Position 6 Christian is transferred to Superior Court. 7 is a waiver of arraignment. 8 is I believe it was released.
No, number 8, you reset
to September 11th.
11th.
Yeah. And those were just my notes, sorry. Released, reset to September 11th. Position 9 was a plea. 10 Ford is a waiver of arraignment for the notice. 11 and 12. That's Gaskin and Green. What are we doing?
11, he was released on September 2nd.
Okay.
What was a waiver?
And Michael Green?
A waiver?
A waiver, okay. That's going to be further notice jail jury. Position 13 was a waiver as well. 14 and 15 were pleas. 16 was a plea. 17 and 18 was released and further notice. 19 was transferred to Superior Court. That's Dalvin Holiday. 20 Holloman. That is going to be reset to September 11th. We're going to appoint Dennis Murphy to represent him. 21, Odell James was a plea. 22, Johnson is a plea. 23, Mack is a plea. 24, Cameron Morton. What are we doing?
I have waiver. Is that right?
That's what I have on, that's what they have announcement.
Yes, Judge.
All right, there's a waiver of arraignment and further notice. 25, Patterson is a, I think it was.
Court rejected the plea
Rejected,
negotiation and it's being reset.
Is it being reset? Are you filing a waiver of arraignment, Ms. Tucker?
Judge, if we can, I believe it was reset for next week, Judge.
Okay.
But
Reset to September 11th, pending whatever probation does with this current case. Unique Patterson was a plea. Judy Pearson was a plea. Jason Reed, 28, was a plea. Robertson, 29, was a plea. 30, 31 were pleas. 32 is released on a 500 signature bond through the jail. 30, so this will be a further notice. I mean, it'll just be released and further notice. Walker was a waiver of arraignment and further notice jail jury. 34, White was a plea. 35, Wilkins is reset to September 11th. 36, Wilson was a plea. 37, Denard Wilson is a waiver of arraignment and further notice. Same announcement for position 38, waiver of arraignment. And add-on, Sophia Harris, also known as Iona Adams, was a plea. All right, Mr. White, thank you so much. You are free to go. Have a great weekend. Thank you.
Thank you, Your Honor.
All right, Ms. Tucker, you are as well. All right, let's address Mr. Alan Lewis, who is our bench warrant. Mr. Lewis, please unmute.
Hey, how you doing, Your Honor?
I'm doing good, thank you. Mr. Alan Lewis, case number is 25 CR 3371B. He's accused of 5 misdemeanor offenses, 2 counts of battery family violence, 2 counts of simple battery family violence, and simple battery from September 17th, 2024. Mr. Lewis has a bench warrant, and he has filed a request to set aside the bench warrant. And okay, and this was back on August 4th, 2025, where Mr. Lewis left the court before without court permission or without leave of court, and his bond was forfeited. All right, Mr. Lewis, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Ms. Patton, you're with the, are you representing him?
Yes, Your Honor.
Okay. And yes, what happened in Judge Porter's court?
Yes, Your Honor. Mr. Lewis was present. He did fill out an application for public defender services. there was confusion about who he gave the application to and whether he was excused or not at that point. And so when he left and the judge called his name, no one had a physical application to confirm that he had applied, and whether he qualified or not. And so she forfeited his bond. I did reach out to, or Mr. Lewis reached out to me, and then we had a conversation. And then I went and requested that the warrant be set aside and lifted.
All right, and does he qualify for the public defender's office?
He does, Your Honor. I filed an entry on his case.
All right. Ms. Falk, what would you like to respond to? I mean, what's your response?
I mean, he showed up. That's half the battle. So usually we don't have people show up. I will, this is, I'm going to be honest, I'm fine with a reset and him going back to court. If he has signed up, if he's gone out and gone ahead and filled out the paperwork and did qualify, we're fine with a reset.
All right. Mr. Lewis, Ms. Falk, the prosecutor is absolutely correct. It was half the battle was done. But remember, when you are in a court of law before a state court or superior court judge, you never leave the courtroom until the judge gives you permission to do so. Otherwise, you are stuck with an outstanding warrant for your arrest.
Yes, ma'am. I had
I don't want to hear an
Mr. Lewis.
explanation. I do not want to hear an explanation. All I'm letting you know is that before you step out of the courtroom, you go back to the attorney and say, does the judge give me permission to leave? And if the judge did, then you can go on your merry way. Do you
Okay.
understand?
Yes, Your Honor.
I'm going to set aside the bench warrant. And Mr. Lewis, if you change your address, make sure that the first person who finds out is the state court clerk's office in writing immediately.
Yes, ma'am.
That you don't miss out on your future court dates and you never leave without Judge Porter's permission.
Yes, ma'am.
All right. Ms. Patton, if you will submit a proposed order to set aside the bench warrant,
Yes, Your Honor.
and please direct that to Ms. Katrina Lewis. The sooner she gets it, the sooner she can send it to jail records.
Thank you, Your Honor.
All right, thank you. All right, Mr. Lewis, be careful you don't get pulled over between now and Saturday, because we still have to wait for my order to be filed.
Okay.
All right, thank you.
Is I'm gonna get the paperwork for it?
That's what I'm saying. Don't get involved with the police between now and Saturday until I file the order.
I didn't worry about it. Okay. Yes,
Otherwise,
Your
we'll be talking from the jail.
Honor. Yes, Your Honor.
All right, take care.
All right.
All right, that brings us back to Kiara Harrington. Please unmute and start your video.
Hello.
All right, which case are you inquiring about?
This is for Malachi Ford. I have the case number as well.
No, I don't need it. Thank you. Just hang on.
That was a waiver, Your Honor.
Yeah, just a minute. Malachi Bernard Ford, case number 25 CR 4962C. He has submitted a not guilty plea, and his case is going to be further notice for a trial. He's still in jail.
That wasn't what I understood. I understood that he told the state that
That's
he
the
wanted.
decision. That's the decision that he made with his attorney.
Okay. Okay, no worries. Thank you.
You're free to go. Thank you. All right, let me see. I think we've concluded with the SAP calendar, with the bench warrant calendar. The only item is so we can stop the live stream and the recording, please. And yes, Ms. McLeod, are you okay? She must be on this. Yes, Ms. Greenhouse?
Yes, thank you. I was just wondering if you need me to stay on for any possible pleas from the
Mr. Haddad?
competency.
Are we taking any pleas from the 11 a.m. calendar? Please unmute.
I will say